because he had the authority to give life and take life away. And what they were doing was sending the adventurers and the planters. Now, it's not Johnny Appleseed coming over here throwing seeds, kids. The adventurers and the planters were stockholders and corporations and people coming over here setting up colonization in America. And the words New England should really grab you differently now, because New England isn't just New England, it's New England. It's England, but it's a new place because it's actually going to be a new head start over here. We're going to call it New England because over here we got Old England, but it's awful small. So we have to stick all our people over here. We're going to set up colonizations as for-profit corporations for the Crown of England that goes back into the King's contract with the 13 United States, which this country reneged on, but the King forgave the interest. But he never forgave the debt, which is still owed, which is probably taking us back to the international bankers that are now trying to claim the debt, and they're using all of us, which is like 4, 5, 6 generations later, responsible for a debt on a contract we didn't sign. But they're using the argument, well, we don't have to go by the Constitution because we never signed that contract. Really? We didn't sign your debt either, so kiss off.
All right, now, with what we have sit here and brought up, Jeanette and I have taught, 1492, Vatican claims all material rights, all land, everything. 1600s, the King of England comes over, claims all rights on all land, all fish, all gold, all silver, all trees, everything. 1933, employees of ours filed bankruptcy and turned it over to international bankers, which now claims they have ownership, and we've got 2 previous owners that nobody bothered going to ask permission to buy, sell, or anything.
Ding, 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 ding.
Well, let's go just a second. Go back to Nostradamus 500 years ago when he predicted that in the end, no one would know who owns the houses and the fields. Well, folks, that's what we're trying to explain to you right now. They're buying, selling, stealing, conniving, backstabbing, underhanded, transmitting, transferring, and fraudulently conveying anything they can get their hands on. They're robbing Peter to pay Paul, to rip off Mary, to sell Mary back over to Paul, to pay back Peter.
Now, like I said, what we're getting into tonight, people, is just a line of thought of something that has never came out to all of you at this point in time because nobody got into anything this deep.
Okay, so to confer on this trafficant issue, because it was all Speaker of the House, but nobody could actually get any documents on this bankruptcy of 1933. I got a hold of the Library of Congress this morning, okay? And what I got from the Library of Congress, I spoke specifically with them, and I asked for the Emergency Banking Act of March 9, 1933, 48 Stat 1, Public Law 89 through 719. And I got it from him, and it's also entitled to provide relief in the existing national emergency in banking and for other purposes. And the other document that I needed was the HJR 192 that you hear Rod speak of frequently. And that's the 73rd Congress in session June 5th, 1933, which I obtained. And it's also entitled to assure uniform value to the coins and currencies of the United States. That's volume 48, page 112 through 113. The first one is volume 48, both documents, and they're both 1933. I do, in fact, have those. Rod's got a copy of them. I sent that out to you, Harvey. Carl, you got a copy as well. I cannot put PDFs up on the blog, but I do have them. Let's see if I can bring one up here. This is the 48 Stat 1933. It's an act to provide relief to the existing national emergency in banking and for other purposes, and I'm reading this right off of the congressional record. Okay, this is Public Laws of the 73rd Congress. okay, of the United States of America, passed at the first session, which was begun and held at the city of Washington in the District of Columbia on Thursday, the 9th day of March, 1933, and was adjourned without day on Friday, the 16th day of June, 1933. Franklin D. Roosevelt, President. John N. Garner, Vice President. Key Pittman, President of the Senate pro tempore. Henry T. Rainey, Speaker of the House of Representatives. And this goes into the bankruptcy.
I see standard documents that everybody pulls, but they did not go in and get into the congressional act of what Traffica was sitting here saying. They did not get into the congressional records of this 13955, which we need to get into. Nobody's ever got into or ever pulled the Chapter 11 court record to see how it was written. Everybody forget all this. The only thing that they've got into is what Jeanette sit here has talked about on these PDFs. That's the only thing people are getting into. They're not looking at a bigger picture of what we're talking about here tonight.
Well, Rod, this is explaining that they always refer to as the Act of October 6, 1917. They are intentionally withholding the terms and conditions of what that act is. It says right here, Section 1, the actions, regulations, rules, licenses, orders, and proclamations heretofore hereafter taken, promulgated, made, or issued by the President of the United States or the Secretary of the Treasury since March 4, 1933, pursuant to the authority conferred by Subdivision B, Section 5 of the Act of October 6, 1917, as amended, are hereby approved and confirmed. Here's Section 2, Subdivision B of Section 5 of the Act of October 6, 1917. That's your 40 Stat L411, as amended, is hereby amended to read as follows. And here's what you're going to need, Rod. You're going to love it. Paragraph B, during time of war, or during any other period of national emergency declared by the President may, through any agency that he may designate or otherwise investigate, regulate, or prohibit, under such rules and regulations as he may prescribe by means of licenses or otherwise, any transactions in foreign exchange, transfers of credit between, or payments by banking institutions as defined by the President, and export, hoarding, melting, or earmarking of gold or silver coin or bullion or currency by any person within the United States or any place subject to the jurisdiction thereof. And the President may require any person engaged, stand by, I lost my place here, in any transaction referred to in this subdivision to furnish under oath complete information relative thereto, including the production of any books of accounts, contracts, letters, or other papers in connection herewith, in the custody or control of such person either before or after such transaction is completed. Now, what does that tell you, Rod?
Okay, this goes back in under this Title 12, 95A and 95B, which takes you over to Volume 48 under Statute at Large, 1933, 1934, on that 112 pages that goes in and shows where the President turned everything over to the United States Treasury, and the United States Treasury turned everything over to the Comptroller of Currency, where he is responsible for the debt, because under this H.R. 13955, where the United States Treasury is not to sit down and get any compensation. The bottom line is, ladies and gentlemen, we're putting all the pieces together, and we're just getting started because I don't have all of it tonight. We're just hitting the highlights of this for you people to get a different point of view, a different look at what they did, because it just wasn't United States. They did this to other countries. And we've got countries on the line here tonight. I'll guarantee you that they're sitting here listening. They were not aware that they got drug into this. And if you go back and check, or if they would go back and check, they will see that their Constitution was overthrown like ours was. This is why, with what Jeanette and this other lady has done on putting this website up on land rights and farming with all of these international hits from all these foreign countries, with what we are exposing, with what we are talking about. We are now pulling international interest. It is for us to sit down to educate us, the people, to get in, to understand what's going on so we can start standing up in these courts, start addressing these issues, but we're also putting this out to the international level because they have the ability to bring them into their courts and prosecute them where we may not see the inside of a court with them. They're going to see the inside of a court with foreigners.
Well, let's go into Section 3. Section 11 of the Federal Reserve Act is amended by adding at the end thereof the following new subsection. Okay? This is in quotations also. Whenever the judgment of the Secretary of the Treasury, such action is necessary to protect the currency system of the United States, the Secretary of the Treasury, in his discretion, may require any or all individuals, partnerships, associations, and corporations to pay and deliver to the Treasurer of the United States any or all gold coin, gold bullion, and gold certificates owned by such individuals, partnerships, associations, and corporations. Upon receipt of such gold coin, gold bullion, or gold certificates, the Secretary of the Treasury shall pay therefore an equivalent amount of any other form of coin or currency coined or issued under the laws of the United States. The Secretary of the Treasury shall pay all costs of the transportation of such gold bullion, gold certificates, coin, or currency, including the cost of insurance, protection, and other such incidental costs as may be reasonably necessary.
All right, now, she used a key phrase here, state of emergency, national security. Remember when we talked about the Pee Wee Coal Company and we talked about the United Coal Miners of America versus United States back in the 1940s? On these case laws, they're up on the website where the state has no obligation. Whenever the government walked into these coal mines and they took them over, flew the flag, posted it, U.S. property, national security, the moment they took over, the government had the ability and they was allowed to take the interest and the profit that they made, but they became accountable for the compensation. They became accountable that they had to buy and pay for everything for the employees. We're in a state of emergency.
Which takes us back to the bankruptcy, that they are responsible for everything. Everything. And you pay Social Security, okay? You're paying into it mandatorily. It goes to the Queen. You're paying into Social Security by mandatory law, okay? But you ask for it to get it, and they say it's a benefit, okay? What Rod is saying, what they're doing is they should be supplying all of our housing, all of our food, all of our utensils, all of our utilities, toilet paper, your food, everything. But they're not.
All right. Now, the thing of it is, if they went into bankruptcy, they went into receivership, how can they turn around and come back out to the people and say, oh, well, we're bankrupt, but you need to pay into us, because the moment you pay into them, they're no longer bankrupt. They now have assets.
Oh, now, I just got these today, folks. I have not even had the opportunity to read them. But here's another part, Rod. Section 4. In order to provide for the safer and more effective operation of the national banking system and the Federal Reserve System, which we have just established as a private corporation, folks, to reserve for the people the full benefits of the currency provided for by the Congress through the national banking system and the Federal Reserve System. Folks, these are all now corporations that they have a vested interest in. and to relieve interstate commerce of the burdens and obstructions resulting from the receipt of an unsound or unsafe basis, and to relieve interstate commerce of the burdens and obstructions resulting from the receipt of an unsound or unsafe basis of deposits subject to withdrawal by check during such emergency period as the President of the United States by proclamation may prescribe, no member bank of the Federal Reserve System shall transact any banking business except to such extent and subject to such regulations, limitations, and restrictions as may be prescribed by the Secretary of the Treasury with the approval of the President.
What we're doing, people, we're giving you food for thought. We're giving you a different perspective than you've ever had with information that we're putting together from out of congressional records, ink on white paper, of how this stuff was set up, where you've heard for years from the time you got into this, anybody and most people brought in one little section, and they were never tying this thing together into a bigger picture. We didn't know who the receivers were for sure. Now we're sitting here finding out. It was the international bankers. How could the United States government be in debt to international bankers before they become a party?
And how can they name the United Nations 12 years before it existed? Here's into Title 2 of this, Section 201. This title may be cited as the Bank Conservation Act. Section 202. As used in this title, the term bank means, number one, any national banking association, and number two, any bank or trust company located in the District of Columbia and operating under the supervision of the Comptroller of the Currency. And the term state means any state, territory, or possession of the United States and the Canal Zone. Now, what part of District of Columbia do we live in, kids?
What part of the Canal Zone do we live in?
That's right. Now, here it's saying possession of the United States. So, what is a possession of the United States? Are they saying that we as 14th Amendment citizens are a possession of the United States? They failed to disclaim any of this.
All right, now remember, we talked here some time ago about the 40 stones. The 40 stones that's laid out for a survey plaque around the District of Columbia, which says on the stones on the inside, facing each other, United States of America. On the back side, it says Virginia or Maryland. These are all pieces of this puzzle that we're looking at, that we're bringing in. See, this is where the problem has been throughout the years. Someone just brought in a couple of these congressional acts and sit here trying to make a big deal, but they was not looking at all of this other stuff of what we're talking about. Ladies and gentlemen, there's a lot bigger thing here that we were never disclosed to, because if the international bankers are the receivers and Congress are the trustee, and they are listed as trustees under Jim Traffica under that one paragraph. Like I said, anything below that, I don't know if it's in the congressional records or not. We need to get our hands on that record and find out. But that one paragraph is, it says the Congress is trustees. It says that we are in a bankruptcy. If Congress are the trustees, then Congress is required to sit down and pay the bet. Now, from what he was getting into in this thing, and it goes down a little farther, it talks about the birth certificate as being what people have sit here and said. The birth certificate is the credit line. This is what they're drawing off of. All right, if this is the case, and like I said, people, we need to pull information on this.
Well, actually, Rod, the trustee is the one who makes sure that in the receivership, the bankruptcy, that the receiver is responsible for handling things accordingly. That means if I'm the receiver of your bankruptcy, that you're in a receivership, okay, you give me your checkbooks, okay? Any deposit that you make has to come through me, and then you give me all of the money. Anybody that pays you, let's say you have an apartment building, and they pay you the rent. That comes to me. That comes right to me, and then I pay all of the debts that you owe by that money that came in through me as the receiver, because I'm receiving all of the income, and I pay that out. Well, that trustee is supposed to make sure that I'm doing my job accordingly. If not, then I'm embezzling the money, and then we have just both violated the contingencies of the bankruptcy, which a Chapter 11 should have been a corporation. A 13 would have been individual. So I'm speculating, and I'm under the presumption that this bankruptcy was based on the fact that the United States never paid back the debt to the king and or the loan back to the Netherlands.
All right, the debtor, people, cannot go to the Federal Reserve and say, print me some money.
That's what they've been doing.
That's what they've been doing.
Well, and look at how many times we've gone to Congress for help when they're appointed. What are they? The trustee. Or anyway, you look at it, they're still involved with it. They're still involved directly in the bankruptcy. And then we go to them for help, and they won't help us because they have a vested interest in the outcome of any case and any matter and any ruling and any legislation and any executive order, because they're still involved with the bankruptcy, and they've got to make sure they keep the bankers happy and screw us, because they've got to make sure, well, if they're alive, we still have the birth certificate, and if they're dead, it doesn't matter because we've got them as a corporation pursuant to the Blackstone Commentaries, Book 1, Chapter 18 under corporation, so that we can make a profit off of them in perpetuity as a corporation.
But now they're selling it overseas to foreign investors, and now by us having the access of the Internet and this website, and we have international people listening, we're now exposing that all the stuff that these courts have done by